Does anybody know why we celebrate Constitution Day? Anybody?
We're made to.
Yeah, I have a question. Kevin Brown, do you know why we celebrate Constitution Day? Because Congress passed an act in 2004, I believe. Better question, why today? Does anybody know the answer to that? Somebody knows. Francisco, talk to me. What's the answer? You don't know? Because Congress, today's the day of the signing of the U.S. Constitution in Philadelphia in 1787. So now you know, 17th of September, 1787. Hence, Constitution Day. Enjoy. Here's what I'm going to do. I am the moderator, which means I don't really get to tell you all that much. I get to moderate, but I still have a few things I want to tell you about voter ID laws. What's happening, the issues to think about as you listen to our speakers this afternoon. So I was browsing the internet, and here's what I found. I wanted to frame the issue for you. Here's one side of the voter ID debate. IDs. You need IDs for all kinds of stuff. For buying beer, for going to the movies, I didn't know. For cashing a check, for driving a Volt, I'm not sure what that means. For using your credit card, for working at the Justice Department, and, of course, some argued you don't need it to vote, and I quote, for the most powerful man in the world. And I think they're alluding to Chicago politics. That's one side, right? You need IDs for all kinds of stuff. Surely you need IDs for voting. Well, here's the other side. This is coming to us by Joel Pett, who visited the law school some years ago. It's a very, very interesting, funny cartoonist. He says, this is, of course, at the voting booth, well, we'll just need a Swiss passport, some blank trust documents, keys to your houses, carry concealed license, or a notarized copy of your signature from the Mayflower's log. Yes, you need some things, but how much is the right amount? That's, you'll see in a moment, the debate in a nutshell. Here's 5 issues I want you to consider as we talk about voter IDs this afternoon. The first is the one of voter qualifications. This is clearly a duty that the Constitution places on the states. Article 1, no question, that's not all that debatable. There's no question about that. Question, what hurdles must a voter overcome? Right, there's all kinds of things that you're asked to do before you can vote. For example, age, gender, residency. Of course, this is also a very tricky area because this is exactly where, in the past, voter suppression practices have surfaced. For example, poll taxes, literacy, grandfather clause, and good character requirements. Right? It's a really, really hard, interesting tension historically between vote dilution and suppression on the one hand, and electoral legitimacy on the other hand. It is one thing to ask voters to comply with some requirements. On the other hand, you can't ask so much or some things that will lead to suppressing the vote. Second theme to think about congressional powers. Under Section 5 of the 14th Amendment and Section 2 of the 15th Amendment, this is clearly an area where Congress has a lot of power to do what it needs to regulate national elections. Third theme to think about is the question of politics, by which I mean partisanship. Think Republicans and Democrats. The question here is also quite simple. Should we place partisan officials in charge of designing our electoral structures? Put another way, should partisans be in charge with the duty of safeguarding electoral integrity? It goes without saying that we get, usually in this area, what we pay for. It's a classic fox hen house problem. Fourth, of course, is race. This is, of course, a classic case. If you think about the fact that the 15th Amendment was essentially disenfranchised for most of the 20th century, in the face of the 15th Amendment. Not only until passage of the Voting Rights Act were blacks finally able to regain the right to vote, and of course other minorities soon thereafter. Finally, for what I take to be the biggest question here, it's funny or interesting because we're going to talk about Crawford in a moment. Here's what I consider to be the central question in constitutional law. What is the proper role of the federal courts in answering this question or related questions? Interestingly, in the Voting Rights Act context, this relationship between the federal courts and the political branches has been one of akin to a partnership. Once upon a time, courts wouldn't intervene, however, in the law of democracy writ large, because this was, and I quote, the classic political thicket. We're not doing this. We ought not do this. Of course, if you know anything about politics, you know about the court. That's no longer true. As we talk about voter ID laws for the next half hour, 45 minutes, and then, of course, the Q&A, I want you to think about these themes and questions. They will surface in different ways. Before we turn to our distinguished panelists, I want to just point out a few figures about voter ID laws, which, by the way, they're spreading across the country like wildfire. In 2011, for example, 34 states considered voter ID legislation. That's 34. This year alone, legislation was introduced in 32 states. They included new voter ID proposals in 14 states, states such as Illinois, Iowa, Maine, Maryland, Massachusetts, Minnesota, Nebraska, New Hampshire, New Jersey, New Mexico, New York, North Carolina, Pennsylvania, and West Virginia. There were proposals to strengthen existing voter ID laws in 10 states: Alaska, Colorado, Delaware, Florida, Hawaii, Kentucky, Missouri, Ohio, Oklahoma, and Virginia. And there were bills in 10 states to amend existing laws. These were Georgia, Kansas, Michigan, Mississippi, Oklahoma, Pennsylvania, Rhode Island, South Carolina, Tennessee, and Wisconsin. There's also litigation, you may know, underway in Ohio, Pennsylvania, and Wisconsin. In the remaining of our time, our speakers will speak about these issues. We'll talk about, namely, the Crawford case, which is the Indiana. Turns out this is a big case in the area, the Crawford versus Marion County Election Board. We'll also talk about the effects of partisanship on elections, and of course we'll take your questions as they come up to us. So here's what we're going to do. Passing it on to our distinguished panelists. We'll go, Professor Hershey's going to speak first, then we'll go and talk about Crawford, Mr. Groth, and Mr. Oh man, I'm blanking out. Fisher. That's embarrassing. Could you delete that from the tape? Anyway, as I said, we'll break at 10 to 1 o'clock. And then if you have to go to class, please do it quietly, and then we'll reconvene and take the Q&A. Without further ado, Professor Hershey.
We need game show music right now.
Okay, I'm delighted to see you all. I'm very glad that you're interested in this area, and I hope we'll be able to shed further light on it in the next few minutes. Let me start by offering some context. Laws and rules governing the right to vote have changed frequently throughout American history. It didn't happen because the original laws governing the right to vote were handed down to us on stone tablets, and then for some reason a big arm came down and said Amendment number 1, Amendment number 600. On the contrary, laws regarding the right to vote are made by lawmakers, by elected legislators, and these lawmakers understandably have a variety of motives. They want to make good public policy, but there's not, as you know, just one way to define good public policy. Depends on the lawmaker's view of what should be maximized. And most lawmakers are also motivated by the fact that they want to win re-election, and they want other legislators who agree with them to win re-election as well. So laws, like any other rules, I need not tell you, are never neutral. They inevitably affect different people and groups differently, depending on those persons' situations, their circumstances, their resources. And this is obviously the case governing the right to vote as well. We can look at a whole series of changes in voting rights laws since the beginning of the Republic And we can see not just how they've changed, but how each change has benefited some groups a lot and others not at all. And if we assume that legislators have brains, we can guess that in many cases those laws were intended to occur by the people who wrote and passed those laws. So let's start with an example. You know that at the beginning of the Republic, even though the Constitution, of course, started by the words, "we the people," voting rights were not granted to all the people. It's the states that can decide who can vote in accordance with some basic federal rules, and just about all the states said that only white men who owned property or paid taxes could vote. How come? State legislators were understandably worried about the intentions of all those non-property owners and immigrants. You probably would have been too if you had been in their shoes. There was no other working democracy at the time. Nations were ruled by a select few with a lot of resources. James Madison and a lot of other founders wrestled with the fear that if you give some power, such as voting rights, to all men, what's to stop the poorer ones from voting to redistribute the wealth of the wealthier ones? Property rights had been a focus of the founders. They had no other example of a democratic state to look to be reassured that you could give everybody the right to vote and property rights would be protected. So the new state legislatures, which included many of the folks who wrote the Constitution, thought it would be prudent to restrict the franchise to white men of property. And yet, within less than half a century, almost every state had changed its laws to give the right to vote to men regardless of their property owning or tax-paying status. How come? It wasn't that all of a sudden a bunch of folks woke up to the idea of the rightness of universal white suffrage for males. It was that Thomas Jefferson, James Madison, and others had realized that property owners and taxpayers were more likely to vote for the candidates of the opposition party, the Federalists, which better represented their interests. If they were going to change the outcome, the Jeffersonians needed to change the rules. I have no doubt that the Jeffersonians also believed in small d democracy, just as the Federalists did. They just defined it differently. And the Jeffersonians also figured, bless you, that if you give voting rights to people who didn't own property, the Jeffersonians would win more elective offices. And that's what happened. So this expansion of voting rights helped the party that promoted it, the Jeffersonians, to become the majority party. Similarly, in an instance that I'm sure is very familiar, when Southern legislators during the mid-1900s voted for a variety of laws that would take away voting rights for Black Americans, they certainly knew that these more restrictive voting rights, voting laws, would help not only Southern whites win elections, but also the Southern states' Democratic parties. These Southern white Democrats knew that Black voters were more likely to support the party of Lincoln, the Republicans, and to defeat Democratic candidates. Now, I'm not trying to offer you a conspiracy theory of politics, but just a world in which people have some clue what will benefit them and what will harm them and people similar to them. And it's only reasonable to assume that just like we are, they can figure out how any given change in the law will affect their interests. And it's not at all shocking to suggest that people will promote their own interests. As Madison said, that's why a republic or a representative democracy is such a good idea, because it lets people do that, which they will ordinarily do, in a peaceful way, rather than through violence. For most of our history, the changes in voting rights laws have tended to expand voting rights to include groups that did not yet have them. You know what the pattern is over time. But it was not a one-directional pattern. For instance, consider the change in the 1890s to require that in order to vote, people must first register. Before the election, at times when interest in the election probably at its lowest, people had to go someplace and fill out a registration form and then come again to the poll on election day. This was a pretty novel idea by the progressives. It still is not used in most other democracies. The progressives were reform-minded Republicans who were suspicious of the lower-class foreign immigrants who propped up the political machines at the time. And the passage of registration laws, in fact, did reduce turnouts from about 80 to 85% in the 1890s to about 65% nationally after that. And particularly the turnout of lower-income voters. And that had partisan consequences too, of course. The most recent efforts to change voting rights laws have taken two opposite directions. One has been to further expand voting rights by allowing people to register closer to Election Day, sometimes even on Election Day in many states, and at a variety of sites that were not permitted before, such as driver's license bureaus and social services offices, early voting, voting by mail. The other direction of these laws has been to fight this expansion. Shorten early voting periods, for example, require people to bring some specific type of ID with them in order to cast a ballot, whether it's citizenship papers or photo IDs. Now, note that even in states that do not require voter IDs, studies have shown within the last 3 years that they have nevertheless been required by many election officials. Local election officials have a lot of flexibility as to what they can ask of people. And in many states where there are no voter ID laws, some voters, in fact, have been asked for IDs, and these have not been a representative sample of all voters. So, what's the partisan effect of the changes in these voting rights laws? If, in theory, you expand the number of days for early voting, anybody could choose to vote early, right? So the partisan impact should be minimal. Except that in a number of big states with large African American populations, an early voting period that includes a Sunday has often generated larger black turnout as black churches have mobilized their members to go directly from Sunday morning services to voting sites, which is, of course, the right. Blacks are the most reliable Democratic voters in the United States. If you allow Sunday early voting, then in practice, we find a higher percentage of black Democratic voters. If you change the law to exclude Sunday voting, as Ohio made an effort to do, that increment of black Democratic voters is less likely. If you require that voters bring some sort of ID to the polls, then clearly those who lack that form of ID will face an increased burden in order to vote. The state of Texas, for example, permits state hunting licenses to be used as appropriate voter IDs, but not university student IDs. Now, it's obvious that the people who hold a hunting license have a different demographic profile. The folks with the hunting licenses are likely to be older, on average, more likely to own a gun, obviously, more likely to be male than are the folks with the student IDs, and these demographic differences have partisan consequences. The people who hold hunting licenses are more likely to vote Republican than are those who hold student identifications. That advantages, of course, Republicans over Democrats. We don't see that particular distinction in Indiana law yet, but we do see that the state voter ID law requires that prospective voters show one of several IDs that are not universally held by Indiana's eligible voters. A driver's license, for example, is probably the most commonly held ID among those that are allowed by the state law. And all of us who have driver's licenses assume that everybody else has driver's licenses as well. But there are demographic groups that are less likely to hold a driver's license. Empirically, elderly people who don't own a car or are not allowed to drive anymore, poor people who can't afford a car, African Americans who tend to have those characteristics in larger numbers, disabled people. And we know from several surveys that have been done of various demographic groups and their likelihood of holding a driver's license, 3 of these 4 demographic groups are more likely to be Democratic than Republican. So it seems pretty clear that the Indiana voting rights law, just as the other changes recently in voting rights laws, inevitably advantage some demographic groups over others, and those effects have partisan consequences. We can see that also clearly in that Indiana, as in virtually every other state that's passed some kind of voter ID law. The law was always proposed by Republican legislators, passed by Republican-controlled legislative houses, and opposed by Democratic legislators. Pennsylvania's law, for example. In March, Pennsylvania state legislature enacted one of the toughest ID laws in the nation, with the support of no Democratic legislators and all but 3 Republicans. The governor, who is a Republican, who signed it, said it would prevent people from cheating in our elections in a state where there is a Democratic registration advantage of 1.1 million people. The governor's estimation was that 99% of the state's voters already had an acceptable identification. And lots of other supporters of the law question how any responsible grown-up wouldn't already have the right card in a society where photo ID is required to use a credit card or buy alcohol or cash a check. But interestingly enough, it turns out that there are many people who don't have driver's licenses in Pennsylvania and who don't hold credit cards. What is true of many people is not true of all people. It doesn't shock you, I imagine. When that was publicized, the law was then revised to include a non-driver card, which in turn required a raised seal birth certificate from the state and a social security card, as well as 2 proofs of residency. That law was later amended to include a narrow set of other photo IDs, including a U.S. passport or a military ID. All of those had to have expiration dates. Then the state had to define, as you know, the legislators pass the laws, they don't get to enforce them. The state had to define what constitutes an institution of higher education. And it turned out that of the 110 institutions that were defined that way, 91 did not include expiration dates on their identification cards, and therefore these were not relevant to the voter ID law. They could not be used. Aside from Pennsylvania's, Indiana's voter ID law is arguably one of the most restrictive in the nation. And so, after all this, my point is, as I hope has been obvious by now, given the history of voting rights laws with partisan consequences, we have to be very careful to evaluate any change in any state's voter rights laws to make sure that it is not tilting the playing field. And let me turn to the combatants in this particular case and let you hear directly from the front.
Good afternoon. My name is Bill Groth, and I'm very pleased to have been invited to address this group. It's a personal privilege for me, particularly since my oldest daughter was president of ACS while she was in law school down there for a year. Tom and I were discussing who should go first, and he made me go first. Probably because we're in a Section 2 jurisdiction. If we were in Section 5, you'd have the burden of proof. But I want to talk a little bit about my experience with Crawford, but I also want to get into the Pennsylvania case, which I think is somewhat more topical. Let me say as a prefatory remark that, as Professor Hirschman indicates, the right to vote is not, in so many words, enshrined in our Constitution. But the Supreme Court has repeatedly held that voting is protected from denial or abridgment by the 14th Amendment's Equal Protection Clause. Voting is also the subject of numerous constitutional amendments, including the 15th, the 17th, the 19th, which granted women the right to vote, the 23rd, the 24th, which banned the poll tax, and the 26th, which gave 18-year-olds the right to vote. While the Supreme Court in Citizens United expansively construed the First Amendment to strike down state and federal laws seeking to limit corporate and union spending on political advertisements, it has never explicitly held that the First Amendment protects voters from burdensome or unnecessary state regulations on the right to vote. In 2008, in the case that Tom and I were involved in on opposite sides, the United States Supreme Court in Crawford upheld Indiana's 2005 photo ID law against a pre-enforcement facial challenge under the 14th Amendment. Although Crawford left several questions unanswered, it did establish the legitimacy of the state's interest in regulating the exercise of the right to vote under the guise of guarding against voting fraud. Even an extremely rare and virtually non-existent species of voting fraud, in-person voting by imposters, that there is no evidence has affected a single election result anywhere in the history of this country. States not covered by Section 5 of the Voting Rights Act now need merely posit a neutral reason for imposing even a burdensome ID law. As the recent Pennsylvania trial court ruling demonstrates, even the strictest of voter ID laws may be upheld despite testimony from social and political scientists that it will discourage hundreds of thousands of otherwise legitimate voters by dramatically increasing the obstacles to casting a ballot that will count. Now, the vice of these harsh and uncompromising ID laws is not in requiring identification, even requiring a photo ID. It is requiring a photo ID that not everyone has, and that many have trouble getting, and then denying the voter who doesn't have the right kind of ID the ability to cast a vote that will be counted. In the past 2 years, several other states, including Wisconsin, Texas, and South Carolina, have enacted what some view as unduly harsh laws, which force voters to jump through unnecessary hoops to prove they are who they say they are, and which lack the necessary safeguards to prevent disenfranchisement of otherwise qualified voters. These laws, in the eyes of many, look far more like attempts at voter suppression than preserving election integrity. I want to talk about the challenge to the Pennsylvania voter ID law because that is ongoing. And in fact, I think we can expect a decision from the Pennsylvania Supreme Court any day now. The law has many similarities to Indiana's. For the first time, it was just passed earlier this year, by the way, it requires all voters who wish to vote in person, absentee balloting is excluded as it was under Indiana law, to provide a specified form of government-issued photo ID. Previously in Pennsylvania, voters could use photo or non-photo ID, including bank statements and utility bills. Under the Pennsylvania law, the new Pennsylvania law, the name on the ID must substantially conform, that's the term of art, substantially conform to the name appearing on the voter rolls, and the ID must contain an expiration date. Unlike registering to vote, which a voter need only do once, this ID must be produced at every election. If a voter appears at the polls without an acceptable form of ID, there is no affidavit option to vote by regular ballot, such as there are in other states, such as Michigan, with voter ID laws. A voter without the required ID in Pennsylvania, as in Indiana, must vote provisionally. And we all know what happens with provisional ballots. The vast majority aren't counted. In Pennsylvania, Pennsylvania has an even shorter period of time to get to the election officials to validate the provisional ballot, and they only provide for 6 days. I think in Indiana it's a couple of weeks. And they also provide that you can validate your provisional ballot by either producing the required ID or swearing out an affidavit as to your indigency. But like Indiana, Pennsylvania has promulgated no rules for telling us who would be considered indigent. When voting and civil liberties groups sought to enjoin the Pennsylvania law in court, the Pennsylvania Attorney General stipulated, as Tom did in the Crawford case, that the state had no evidence that imposter voting had ever occurred, or evidence that imposter voting was likely to occur in the upcoming election. Pennsylvania also conceded that if the law was not enjoined and the law prevented eligible voters from voting, it would impair the integrity of the election. The state offered no evidence from social scientists that its law would enhance public confidence in elections, which is the reason that is often given. After the photo ID law bill had become law, the House Majority Leader in Pennsylvania boasted that the law is, and I quote, "gonna allow Governor Romney to win the state of Pennsylvania," end quote. The challengers presented evidence that attempting to rush the law's implementation prior to the November elections would lead to voter confusion and disenfranchise or discourage substantial numbers of its citizens from voting, because hundreds of thousands of Pennsylvanians have no photo ID. Despite this overwhelming evidence, at least some would say it's overwhelming, the trial judge refused to enjoin enforcement of the law. The case was argued last Thursday before the Pennsylvania Supreme Court. Its decision is going to tell us much about the prospects for future successful as-applied challenges to these laws. It's noteworthy that the Pennsylvania Supreme Court has one judge who is under some sort of criminal investigation and will not be sitting on the panel. The remaining 6 judges are divided equally, 3 Democrats, 3 Republicans. You ask why I've made reference to that fact. I will just comment that in the Crawford case, of the 21 federal judges who heard that case, 5 were appointed by Democratic presidents and 16 by Republican presidents. All 5 Democrats who voted to strike down the law, all 5 of the Democrats who were judges appointed by Democratic presidents voted to strike down the law. Only 2 Republican judges, Judge Rovner at the 7th Circuit and Justice Souter at the Supreme Court, voted to uphold it. I'm sorry, voted to strike it down. I got that mixed up. The other 14 Republican judges, 1 at the District Court, 7 on the 7th Circuit, 6 on the Supreme Court, voted to uphold the law. Now, my own view is that these laws are on a collision course with rapidly changing demographics and practical and legal realities. Since Crawford did not rule out as-applied challenges, every voter who cannot get the ID required to vote without expending significant time and money is a potential plaintiff in an as-applied lawsuit. Each of those lawsuits will expose the state's treasury to liability for attorney's fees under Section 1983. There are also significant unresolved issues over the due process rights a state must accord to a voter who lacks the personal documents required to obtain photo ID. For example, does a person have a state guaranteed right and hence a protectable property interest in being issued an ID to allow him to vote? If so, is the state required to permit a person to prove his or her identity by some means other than those prescribed by state bureaucrats? Financial constraints will also come into play as states with these laws continue to lose millions of dollars in revenues, giving out free IDs needed for voting purposes. My wish on this Constitution Day is that the era of strict voter ID laws will be a short one, and that this nation will soon resume what Harvard historian and political scientist William B. Monroe described back in 1928 as the steady and irresistible expansion of suffrage in America. Thank you.
Okay, can you hear me? Is this on? Okay, great. Thanks to both of you for outlining the critique of voter ID laws as a new development, relatively new development in the procedures of American democracy. And I think one thing that's important to bear in mind, and something that I noticed fairly early on in the constitutional debates over voter ID laws, was that the critique always seemed to center around the assumption that if you set aside the voter ID law, we otherwise live in the best of all possible worlds of electoral law. That somehow the way things were situated circa 2004, before at least Indiana came along with its law, maybe circa 2000, even before Bush versus Gore, somehow provides the baseline against which to measure all new laws that affect voting procedures. Now, if you are a, Bill alluded to this, if you're a Section 5 state under the Voting Rights Act, that pretty much is the way things work. If you're going to change anything with respect to how you're going to administer elections, you have to meet a burden. You have to prove it's not going to be retrogressive. Texas ran into this problem before both the Department of Justice and a 3-judge panel of the U.S. Court, the District Court for District of Columbia. And the state of Georgia, on the other hand, did not. They are a pre-clearance state, and they were able to get clearance for their voter ID law even before Indiana prevailed in the Crawford case. Now, I raise this in part because the Indiana experience lends a couple of little vignettes to how we should think about these laws. Back in 2008, I'm not sure the exact date, there was a very well-publicized incident where the late Representative Julia Carson went to her voting precinct. She took with her her congressional ID, and of course everybody there knew her. But she didn't take her driver's license. For whatever reason, the congressional ID didn't match the criteria required by Indiana law, maybe because it lacked an expiration date, maybe because it lacked a photo, I'm not really sure. But she was turned away, and eventually she went home and got her license or whatever she had, and she was able to vote. But of course it made huge headlines, because why would anybody deny Julia Carson the right to vote? What's going on? And, you know, it was a political stunt, but that's what politicians do. I don't begrudge her for that, that opportunity. But then later, in a separate, I'm not sure if this was the same year, it may have been, I think it was in fact 2008, perhaps that was the primary, perhaps I'm thinking now of the general election, but Senator Evan Bayh ran into a problem, less well publicized. What had happened was that the precinct board of his county had changed his precinct polling place, and he didn't know it. Some, failure of who knows, of whatever it was, notice, or he just didn't read the mail, any number of things can come up that people would not realize. And it happens, it's happened to me before, when I've assumed I knew where I was going, and I had to be redirected somewhere else. And as a consequence, he almost did not get to vote in that election, because of the way that the election administration officials had reconstituted the precincts or reassigned precinct polling places. And he eventually made it to vote, and all was well. But if that was an opportunity perhaps for one of the most prominent politicians, one of the most successful politicians in Indiana history, to miss out on the right to vote because of some sort of administrative regulatory requirement, who knows how many people who don't have a sophisticated understanding of the election system, that perhaps don't know where to call, that perhaps don't have people there to help them, might run into a problem where they're turned away at the last minute because they didn't know the proper precinct polling place, and they don't have time to find out where they're supposed to go. They're well beyond the opportunity for absentee voting. It's going to be a lost cause. There are any number of people that could happen to. Well, that doesn't get a lot of attention. We're all pretty used to the idea that if you're going to vote, you're going to have, for the most part, going to have to show up on election day and vote in person at the prescribed precinct polling place. Now, there are exceptions to that, and in recent years we've seen some reconfigurations. Again, we have early voting in Indiana, where you go to the clerk's office. There's been some experimentation with voting centers where they have places where several precincts voters can go to vote. But by and large, it's kind of sort of an ingrained part of the American electoral process that you have to show up on election day. You're not entitled to vote wherever and whenever and however you want to. You have to use a prescribed ballot. You even have to announce yourself when you get to the precinct polling place. So a lot of voting requirements may incidentally exclude people from voting because they're not aware of the requirements in advance, because they don't have the resources to figure out how to register to vote, even with voter, and perhaps because, incidentally, they don't have, as is the topic of today's conversation, the proper ID that now allows them to vote. But it's interesting to me that we focus on voter ID as somehow a tipping point, constitutionally, that is different in kind from other voting requirements that we're all quite used to. And I don't know why that is. I can't say I've ever heard an explanation for it. Maybe I'll get one today. They'll make it enough. But I think it's something important to bear in mind, because unless we are going to assume that all states are essentially Section 5 states, that we all have to prove our way into adjusting our voting regulations, the standard is not, are we doing something different? The standard is much different. And in the Crawford case, the Supreme Court said it's certainly not strict scrutiny. It's this sort of amorphous balancing test of, have you placed a severe burden on the right to vote, and is that outweighed by the government's interest in protecting the integrity of elections? In our case, the severe burden was not well demonstrated, or demonstrated really at all. Now, it's interesting, if you look at the data, one of the requirements that we have, excuse me, that everybody, I think, would agree is constitutional, although I say that and then I remember maybe that's not quite right given some of the arguments that we had to deal with in the Crawford case, is that you have to register to vote. Now, in Wisconsin, it's an exceptional place. You have same-day voter registration. I'm not sure quite how it works. I think it's there's a little bit of a burden there, but not much. It's a pretty open-ended process where you can register the same day. But that's not constitutionally required. In Indiana, I think you have to register 30 days or more in advance of the election. Well, it turns out that at least the way the data stood in 2008 when we went to the Supreme Court in Crawford, maybe I should date that back a couple of years, but when we built the record in 2005 and 2006 case, the data was that about 66%, 67%, somewhere in there, of the voting age population in Indiana was not registered to vote. The voting age population, however, managed to acquire a license or state-issued ID card 99% of the time. 1% of the voting age population in Indiana did not have a license or state-issued ID card. That translated to roughly 43,000 individuals. It comes out to about 1/2 of 1% of likely voters if you look at the percentages of those who actually, of the voting age population that actually turn out. A minuscule percentage, especially when you compare it to other barriers to the right to vote. Registration, who knows about some of the more mundane procedural requirements like actually having to go to the polls. So it really, in terms of the data in Indiana, doesn't stack up as a major impediment relative to other requirements of the right to vote. So I think that was a pretty significant factor in our favor. One of the other significant factors in our favor, in fact, probably the most significant factor in our favor, is that we were never confronted in the case with anyone, any individual who was unable to vote because of the voter ID law. There were individuals that were identified at the beginning of the lawsuit that perhaps might have trouble, but it turned out either they already had ID and didn't realize it, or they fell into one of the categories exempted by the law, such as the elderly, those over 65 who may vote absentee by mail automatically. You don't have to actually be absent, they just, by virtue of the law, they can vote by mail without voter ID. The disabled fall into the same category. Lots of broad exceptions that really take into account some of the critiques that we often hear from those who oppose this law. So that, I think, was almost at a rhetorical level a very significant factor in our favor. We never really had to confront a situation where there was somebody where it was just impossible for them to be able to vote because of the law. An interesting side note is that one of the amici for the other side in our case, I think it was the League of Women Voters. I'm not sure if it was the state or the National League, but they had thought they had identified a couple of individuals that were not going to be able to vote, or had been turned away perhaps because they didn't have the proper identification when they went to vote. Well, it turned out that one of them, when she went to vote, she had a driver's license, but it was a Florida driver's license. And she had also, as it turned out, also claimed a homestead exemption on her home in Florida. Is that an example of the voter ID law standing as an impediment to the right to vote? No, that's actually an instance where the voter ID law worked as intended. Somebody who was not a legitimate resident of Indiana was not permitted to vote, even though they were registered in Indiana as well as in Florida, and turned up in order to vote. So time after time we hear stories, we hear the parade of horribles about how this law is supposedly going to have negative impacts on various categories of individuals to vote, and they just don't pan out. Now, Professor Hershey has very ably described partisan motivations that historically seem to lie behind a lot of changes in voting law, and it's worth commenting as an aside that partisan motivation, while not 100% excluded from the constitutional analysis about election law, is fairly narrowly permitted to affect that analysis. So there was a couple of cases on this issue, and the most recent one that I can recall, Beef versus Jubiler, was a case where Justice Kennedy, the one that we are all trying to please these days when we go to the Supreme Court, he said that, well, I'm not sure that there's ever going to be a situation where, for example, in the context of gerrymandering congressional districts, that there's ever going to be a case that somebody can make that partisanship was an unconstitutional factor, the way that race could be, the way that other factors could be. But he said he's not willing to exclude it completely, so it sort of hangs on by a thread as a factor in constitutional analysis and political regulatory realm. But it's certainly not something that you want to resort to as your main argument. And it reared its head a little bit in the Crawford case, but it was never, I think, front and center. It was always sort of in the background, a sort of rhetorical reminder, hey, let's not forget what this is all about. Judge Terry Evans of the Seventh Circuit had quite a memorable dissent in the case where he said, let's call this what it is. This is just an attempt by, he didn't say it quite like this, but it was pretty vivid, Republicans to make sure Democrats can't vote or something to that effect. He was, Judge Evans, one of the great writers, and I think underappreciated writers of the federal judiciary. But as we look at the data, we see that it doesn't really pan out. And there was, in fact, a survey done after the law went into effect, I can call it up here, that showed that, in fact, we're not looking at a law that, if intended to be partisan, if intended to have a partisan impact, could in any way be described as successful. So you had this study by this person named Emilio at the University of Missouri, and he described that in the wake of this Indiana voter ID law and the elections that followed, comparing those to the elections that came before, doing the sort of before and after analysis, he said the only consistent and frequently statistically significant impact of photo ID in Indiana is to increase voter turnout in counties with a greater percentage of Democrats relative to other counties. So in just, you can think back, well, what happened in the years following 2005 when the law was enacted? What happened electorally? Well, among other things, the Indiana House went from Republican to Democrat. It's since gone back, but that was one of the elections in the meantime. And in 2008, among other things, we, as a state, voted for a Democrat candidate for president for the first time since 1964. So, if that was the intention, it certainly has not been a successful effort to block sort of partisan advantage. Now, it's interesting that when we look at the critiques of the voter ID laws in general, in terms of the constitutional critique, we deal a lot with a lot of marginal issues. And one of the marginal issues is how exactly did Indiana go about implementing this? Did we do it in a way that was sufficiently accommodating to those who might not have identification? And a lot of times this doesn't actually get to the core issue with voter ID, but merely is a reflection of hesitancy for change and reluctance to go about the business of permitting people to become accustomed to the law. Even Justice Breyer, one of the dissents in the Crawford case, acknowledged that in general, voter ID laws at their core seem to be constitutional. His concern was that Indiana did not follow the path laid out by a private commission called Baker Carter that had studied the need for electoral change. We didn't implement it gradually over a period of years. Perhaps we didn't do enough to make IDs available based on blueprints set forth by this report. And he said, I know the Baker Carter Commission isn't the Constitution, but that seems like a pretty good place to go for some sort of middle ground. So even he wasn't disagreeing with the idea of voter ID at its core. And so in the end, all we have are two justices of the court as it was constituted, at least in 2008, that thought that there was a constitutional problem with voter ID laws in general. I'll just leave it at that.
It's now pushing 1 o'clock, so if you need to go to class, now is your moment. I'm going to take maybe a few minutes, clear the room, and then we'll take questions.
Hello, everyone. We're going to go ahead and move on into the question and answer segment. My name is Maj Zion. I'm the president of the Black Law Students Association here at Indiana University Maurer School of Law. And we are so excited that you all have decided to stay and ask the panel questions and pick at their brains and figure out what implications these laws really do have on the voter population. I also want to remind everyone in here that September 22nd, 1862, President Abraham Lincoln signed an executive order that really changed the course of America's future. And that was the executive order of the Emancipation Proclamation. It's 150 years since that proclamation was signed. And it means a whole lot to me as an African American, but it also means a lot to this country as a whole. And as Ms. Hershey already said, these voter ID laws have huge implication on the African American voter population. So I really want you all to think about that. And please do not waste the opportunity to ask these great leaders sitting before you some great questions that will actually address concerns that we all have. We'll start with Mr. I'm so sorry, Mr. Louise is going to actually start first, and he will ask a couple of questions, and then he will direct and open it up to the audience. Thank you again so much for coming, and happy Constitution Day.
So we have a very slight change of plan. I thought after listening to one another talking for 10-15 minutes, if the panelists wanted to respond to anything that anybody said, should have said, didn't say, said correctly, this is your moment.
I think I had my chance.
If you don't, it's fine. I got plenty of questions.
I just made a few notes while Tom was talking, so these are kind of random, but it's true that the Georgia law was pretty clear, but as we know now, it was pretty clear over the objection of career appointees and under the supervision of political people. It's now been revealed that it was essentially a political, not a legal constitutional decision. And yeah, I think Tom used 2004. I think 2004, we finally in this country reached something approaching universal suffrage after many, many years of struggle. The only group that really was excluded at that point are convicted felons in some states in the South. And I think there has been a backlash by particularly the Republican Party, which feels threatened by both the existence of universal suffrage or near universal suffrage and the change in demographics. And I think that is what has given rise to these laws. And as we know now, these laws didn't spring up, spontaneously in a number of different states at the same time. There is this shadowy organization called ALEC, which is heavily funded by the oil industry, the Cook brothers, and so forth, which apparently have some sort of think tank, and somebody came up with this bright idea, and Indiana got to be the experimental guinea pig. And since, of course, 2010, when Republicans grabbed control of several other state legislatures, we're seeing the similar bills come up other states, particularly swing states in the upcoming election. Tom also mentioned that we didn't come up with anybody who would have been disfranchised. I would take issue with that, but you know, it's not just about disenfranchisement. The Constitution prohibits abridgment of the right to vote. We did produce several elderly people in Indiana who couldn't get birth certificates because they were born in the South, maybe in the 20s or 30s, born in a home, didn't have a birth certificate, never had one, and there was a lot of other evidence that was basically overlooked by the courts. I'm still today, but I never really said this to her, Professor Hershey produced an affidavit for us, which was, I think, extremely helpful in showing the effects that this law would have on depressing turnout by creating additional obstacles to people, particularly on the lower socioeconomic end of the scale, to be able to vote, or it would just discourage them from making the potentially multiple trips to the BMV to get this type of ID. And the Seventh Circuit, both in the panel decision and in the en banc decision, never mentioned it. They just acted like it wasn't part of the record, and consequently the Supreme Court never mentioned it either. And we just kept hearing from Tom and other people, well, you don't have any live proof of people who you can show are going to be absolutely disenfranchised by this law.
Any dead ones either, by that.
What happened in Pennsylvania is kind of instructive. The lead plaintiff, just a few weeks ago, managed to get an ID. The BMV issued her an ID, just kind of out of the blue. Jim Kramer's, father, who said, he wasn't going to be able to vote, they came up with an ID for him the same day. So we knew that if we produced those people, they were always going to the state was going to manage to find them IDs, get them IDs. And if we found 10 of them, they'd get 10 of them IDs. If we found 100 of them, they'd get 100 of them IDs.
Sounds like a great strategy.
And this was, after all, a facial challenge, not an as-applied challenge. So, and in terms of what the evidence has shown since, I think we have to look at, Tom cited one paper. There are other papers that reach an opposite conclusion about the depressive effect these laws have. We also have Professor Pitt's paper, his article about looking at the voters who voted provisionally because they didn't have ID. I think it was in 2008, and discovered that a large number of them never came back to validate their provisional ballots, either because it was too much of a hassle or they didn't have the required forms of identification. So this is an ongoing struggle. This is not over. Crawford did not end this fight, and it'll continue. I don't know where it's going to end up, but
can I just, the Pennsylvania case, is it strictly Pennsylvania state constitution, or is it also an as-applied under the U.S. Constitution?
no, it's both federal and, I think that's right. I know it's under the Pennsylvania state constitution, but I think their equal protection clause is very similar to the 14th Amendment, and so even if it's not actually, I'm guessing there's no federal count, because otherwise it would have been removed to federal court.
We states love our federalism. We love our courts.
Just very briefly, otherwise it would be where to start. Let me just mention, I think that Bill Gross made a point that is very important, which is that although those of us who are in political science wouldn't know an as-applied challenge from a facial challenge, if it stepped in front of us on the street, we do know there have been a lot of studies that have taken a look at whether or not, there is evidence that people have been turned away from the polls because of a lack of ID who would otherwise meet the criteria of eligibility to vote and citizenship, and B, whether or not the populations of people eligible to vote differ in the degree to which they have the appropriate identifications. And both of these are important. Those people who have not voted and who do not have access to IDs but are legally eligible to vote should not be discounted. Mr. Fisher mentioned one study out of the two that I know of that has not found a difference. There are several others that have. Typically the difference is not large. One of the things we find with people who are not likely to vote currently is that it takes nothing short of dynamite to get them to vote, and so as a result the problems of increasing or decreasing the burden on them are not as consequential as you might think. But generally the difference has been found to be about a 1.5% to 2% drop in voting rates among people who are eligible. That may not seem like very much, but in these polarized times, we have increasing numbers of highly contested elections. I don't need to remind you of 2000 and many others since then, in which the difference is just about 1 or 2%. And in a system such as ours, where we have a plurality vote system, that possible discounting of even a few votes counts.
Let's do this. I'm sure we're running short on time. I have questions. Mine are a bit intricate. I can catch them afterwards. If anybody has questions they'd love to ask, we do. Beautiful. We can.
We'll start with this gentleman here.
You have to turn the microphone on.
There.
Good work.
There we go. Okay. We'll start with this gentleman and then you, and then we'll go back and forth.
Thank you. I did want to point one thing out. A lot of, in fact, the majority of military identification cards do not have an expiration date. They say indefinite, and they are allowed to be used as identification for voting purposes. So you might want to keep that in mind. Are you saying I'm wrong, Counsel? Are you saying I'm wrong?
I've had experience with a fellow who has a VA card.
No, I didn't say VA card. I said military identification card. There's a big difference.
You're apparently the expert on that.
Thank you, I am. I have one, and I've used it here in Bloomington, all right? The second thing is, one thing that these voter laws do not address at all is registration. Everyone must be registered. And if someone is registered, in order to vote, all they need to do is make one phone call to the clerk's office, and an absentee ballot will be mailed, and they can then vote and mail it back, and it requires no identification at all. So under that case, with 1.45 stamp, how can anyone claim to be disenfranchised?
Well, because not everybody is permitted to vote absentee ballot in Indiana.
Absolutely they are.
Except
Anyone
they are
can
not.
vote absentee in Indiana. Anyone.
With respect, sir,
No.
on election day, if you find out that you are not eligible to vote because you don't have the proper ID, it would be wonderful if you could turn the clock back and then request an absentee ballot, but it is too late to do that.
But for a month and a half before election day, anyone can vote.
You have to ask you have to mail in a request for an absentee ballot 8 days before election day. And if you miss that deadline, you can't vote absentee.
It's interesting, I think, that the voter ID laws almost universally exclude absentee ballots, and political scientists do know that absentee ballots are more likely because of the number of military ballots and people who are elderly to support Republican candidates. I don't say that because I intend it to be that way, that the data are the data.
Let me just interject real quick. Could you all, since we're in a room and our law school here has a lot of students that come from out of state, could you all please just explain real quick what the process is into getting absentee ballots so we can make sure that we do abide by those rules of making sure that we posted our request for absentee ballots 8 days, is that correct? 8 days before the election day. Anybody can tell us about absentee ballots?
Well, I can give you some general parameters. I'm not an expert on those details, but basically you have to be, you have to request it far enough in advance that you can get it in on by election day. Or actually, I'm sure it could be posted on election day.
Yeah.
Posted.
Well, like I said, I'm not the expert on it. But I think the important point here on absentee ballots is that absentee ballot fraud is a whole different category of fraud that is addressed by its own set of laws. And voter ID doesn't really go to the kinds of fraud that you see there. And we kept getting the argument as well, why not require it? Why not require photo ID with an absentee ballot? And well, a couple of things, one of which is, well, you'd have to have some special precautions because otherwise you compromise potentially the integrity of the anonymity of the vote. But also, what are you going to do? You're going to get the photo ID. You're going to compare it to what? I mean, there's no real point in having that. Now, some states have started doing that. I don't really get why, but there is just a difference in states in terms of judgments about what's appropriate and what's not. But it's a very different set of circumstances when you're dealing with the casting of an absentee ballot.
Yeah, the comment surprised me when he started talking about absentee balloting, how easy it is. I thought the point was going to be there's fraud everywhere, or could be, rather. It's ripe for fraud. Courts have found fraud. In fact, Crawford talked about fraud in that respect. Now, there's evidence on that point, not on voting at the precinct, so that this is actually a little bit interesting for the point in a different way. So I'm going to save that for later.
Question over here.
Hi there. I'm wondering about one of the arguments I've heard against the voter ID law is since you have to pay a fee to get an ID and you have to have an ID to vote. I guess I'm looking at Harper versus the Board of Elections in '66, and they quote that the state violates the Equal Protection Clause of the 14th Amendment whenever it makes the affluence of the voter or payment of any fee an electoral standard. Is that an argument that you find valid?
No. Well, just one thing to point out. I don't mean to cut you off, but the ID itself in Indiana, you have to be allowed to acquire without paying for the ID. Now, what we often hear in response is, yes, but if you're going to accumulate the documents necessary to get one of these IDs, you might have to pay a fee, so $10 or something for a birth certificate. And our response to that has always been, well, look, you can always associate a voting regulation with some kind of impact, some kind of direct financial impact. Somebody who, going back to the idea of voting at the precinct polling place, somebody who can't get there without paying to get on a bus, for example, is that somehow different from the incidental cost of acquiring a birth certificate? In our view, no. I mean, when you get back to that level, then you can invalidate all kinds of voting regulations because somebody's going to have some incidental cost associated with trying to meet that. So that's, and the court certainly did not find this to be any kind of poll tax.
Can I just comment briefly? I think you raised a very good point. We made the poll tax argument at the district court level, and the district court rejected it, and I believe for strategic reasons we decided not to appeal on that basis. We were later criticized by certain academics for not having done so, but I'm still convinced that the court wouldn't buy the argument, the Supreme Court wouldn't buy the argument. But it is worth noting that I think the poll tax that was struck down in Virginia in 1969 was $1.50, which is like maybe $10 by today's money.
$13 today.
Yeah, and a birth certificate can cost easily from out of state to $20 to $30. That's just one of the costs. So I still think it's a good argument, but until we have a Supreme Court that's willing to, apply the poll tax amendment to this sort of situation, it just isn't going to work.
Could you raise your hand over here if you have some questions?
We have a question.
Well, I was just going to say in regard to absentee balloting, in Texas, the rules you have to be over 65, disabled, or out of the county on election day, not just anybody.
It's basically the same in Indiana.
And then I just had a comment about your disenfranchisement of convicted felons that did not include people with similar names on those lists. Okay, my question is, I was just thinking of to release the burden on the voter and to take it more upon the state in the interest of eliminating voting fraud. What about the person who for some reason is registered to vote and lives at a certain address but doesn't have the proper ID? What considering the role of biometrics in today's IDs, what if they just go to the poll and give their thumbprint or maybe have their picture taken and then say if you're not who you say you are, you're like
I love
2
that.
years in
I can hear the American Civil
And then I
Liberties
think
Union
if there's any
collective
question,
shuddering.
you can go to
This actually came up. No, this actually came up in the district court, as I recall. I mean, there was a point at which, I don't know whether it was Bill's brief or the ACLU's brief or somebody's brief said, hey, look, if they can do this with photo ID, what's to stop them from doing a thumbprint? And my response was, yeah, let's do thumbprints. Obviously, there is the privacy concern. There's potentially, I guess, a Fourth Amendment argument or something like that. But that, I think, is an interesting insight. Now, states get to choose how they want to do things, but if that were an acceptable way for other reasons to do this,
And why doesn't, if everybody has this ID, the constitutional arguments fall away. Why doesn't this, one solution that's been proposed is that we'll be issued identification cards, either by the state or by the federal government. And we have to produce those in order to vote. I think the objection we're going to hear about that is going to be from libertarians and some conservative Republicans, more so, and some liberal Democrats too. I mean, we all kind of don't like that sort of level of state intrusion in our lives. But yeah, I mean, one of the arguments I made is, the state can require everybody to have a certain kind of ID. Why can they require us to produce a sample of our DNA at the polls? I mean, how far, where do you draw the line?
I'm saying not to require necessarily everybody, but just in case, I'm sorry, I don't have an ID, can I give you a thumbprint?
you have to accumulate all that data, which is an enormous cost on the state, so there's a cost benefit the state goes through and all of that too.
Well, the answer to that is somebody comes to the polls that doesn't have an ID, says, I'm Tom Fisher, and I'm willing to swear an oath that I'm Tom Fisher. And I'm the same Tom Fisher who's in that poll book, and let me vote. Let me vote. And if I want to challenge him, if I'm sitting there as a poll worker and I don't think he's Tom Fisher, I can challenge him. And then he'd have to vote provisionally. But in Michigan, all you do is you just sign an affidavit and you can vote by regular ballot.
It seems like a pretty thin barrier between that, I'm trying to prevent fraud. I mean, it doesn't seem like that really is going to achieve much. Now, the interesting thing that I've seen crop up lately is from states where, I'm not sure if this is Virginia or where else, but if the poll workers recognize you, then even if you don't have the ID, you can vote. I thought, what an awful system. So if you're somebody who's known to the poll workers, if you are an insider, you hang out with these people, you can vote. And if you're not, if you're one of those that doesn't participate in politics a lot, you don't know the people associated with politics, then all of a sudden maybe you're at a greater risk for being excluded. And it always has struck me that that's a really inequitable system to make that dependent upon your familiarity to the poll workers.
But apparently it's okay with nursing or retirement communities, because in retirement communities we don't require residents to produce photo ID, because the argument is, well, everybody knows who everybody is in a retirement community.
There was another interesting case from Wisconsin that was, interestingly enough, triggered by HAVA, the federal law that asked all the states to generate good polling lists, which is a very difficult thing to do. And a polling list was generated. The problem was that when it was, we had this issue about the change in century, and there were a number of folks who were older and did not have an exact date of birth, or it wasn't listed on their records. And so they were all listed as having been born in 1900. According to the bureaucratic decision as to what to do with them. You gotta fill out a form, and you can't leave stuff blank. As it turned out, then there were 45,000 people in Wisconsin who were made ineligible to vote because of the fact that they didn't have a birth year listed. And 4 of them were retired justices of the Wisconsin Supreme Court who had been part of the commission that generated this new polling list. And I assume that they then got ID quickly.
I was wondering if you guys see any legal distinction between what happened in Indiana versus what's going on in Pennsylvania in terms of applying the Crawford standard that you guys have talked about, that there's this sort of balancing test. Because I think the numbers that I read for Pennsylvania, we're something like 700,000 people that might not be able to get to the polls. And I'm wondering if you guys think that if there's any sort of distinction that might be made where Indiana might be constitutional, but what's going on in Pennsylvania might not be.
Well, by way of comparison, at the U.S. Supreme Court during the oral argument, Paul Smith, who was arguing for the plaintiff, stood up and said that there were 400,000 people who would be disenfranchised in Indiana. We took issue with that. There's no evidence in the record of that sort. You just have to be skeptical sometimes when you get these grandiose claims, but I don't know the evidence in Pennsylvania, so I can't comment on that.
Well, Pennsylvania, the lawyers in Pennsylvania have the advantage of not making the mistakes that the lawyers in Indiana make, okay, and learning from our experience. But one thing I will say, we had, and this is another fact that is kind of forgotten in the midst of history, we had an expert, a very well-respected expert, who did a statistical analysis and determined, I don't remember the exact number that he came up with, but it was well into 6 figures, the number of Hoosiers who didn't have photo ID. And what happened is the district court just trashed him. I mean, said his methodology was flawed and it didn't accept any of his conclusions. It's interesting that even in the Texas case, the Section 5 case that the 3-court judge just decided, they had social scientists, political scientists on both sides, and they're trying to make these estimates based on analysis of records that the state maintains. And the court wouldn't accept any of their estimates, any of the numbers. So, I'm not even sure that it's just so difficult to make that sort of judgment as to the number of people who don't have ID. We know that they exist, and we just can't quantify them precisely. But on the other hand, there's lots of case law that says if even one voter who's eligible to vote is denied the right to vote, this is an irreparable and significant injury. So I don't know why we need to spend that much time arguing over whether it's 100,000 or 700,000. We know there's a large number.
Well, I mean, even still, though, we know that the Pennsylvania law is more restrictive than the Indiana law, as I understand.
Marginally. It's pretty much the same. I would say Indiana may be only very marginally less restrictive. But it's basically the same law.
We have another question on this one.
Excuse me. Just this weekend, I was talking with somebody from Oregon who told me that voting by mail is the universal way they do it there, and it works fine, and they've been doing it that way for years. And it's my understanding that this bypasses the whole question of voter IDs such as we've been discussing. So what about that? Why doesn't voting by mail require voter ID? And do you think that it would be appropriate to work towards in Indiana?
Well, it doesn't because the reason you don't require it when you've got mail-in balloting is because there's no face there to compare the ID to. So it sort of loses any real purpose at that point. Now, as to whether universal mail-in voting is a good idea, I have to confess I have not given serious thought to that. I doubt that that's realistic in Indiana, but I'm not a legislator or a policymaker. But I can tell you it's not constitutionally required.
That's where we get most of the fraud. Most of the fraud is not at the polls. It is in absentee balloting. Because it's just much easier to pass yourself off as somebody else if nobody's watching you. And that's why we get lots of absentee ballot fraud at nursing homes, where somebody can simply take the ballots that have been mailed to people there, fill them out, pretend to sign them, and send them back. So it's a risk.
I had a question for General Fisher. So if only half of 1% of voters in Indiana would be even potentially affected by not having an ID. And I know we're not a pre-clearance state, so your burden of trial was, of course, only, you know, it was his burden, not yours. But I am interested, what was the driving basis, in, at least in your opinion, behind why we had to have this law in the first place, and why now? Because I understand that's been one of the main critiques, and I didn't hear it addressed because it was the other side's burden of this trial, so we never got to hear. Why, what is the harm that the state is trying to prevent with this law?
Well, it's both the actual prevention of fraud and the installation of confidence in the election process, which has long been recognized by the Supreme Court as a significant reason for states to regulate in this area. But more precisely, the basic narrative is this. So in 2000, Bush versus Gore comes along, and in the context of deciding the case, one of the opinions, I can't remember which one it is offhand, says, you know what, in effect, states really need to get their act together when it comes to regulating elections. What we've seen in Florida is just a disaster, and it really shouldn't be happening in America that elections participate, you know, or sort of operate this way. So, in general, that kind of set out a clarion call for states to start looking at their election regulations on a whole variety of fronts. So that's one thing that gets the train moving. Another thing is that it turns out that Indiana has highly inflated voter registration lists. The expert that we had in our case showed that something on the order of 41% of the names on Indiana voter registration lists were not legitimate for a variety of reasons. And that is a sort of important baseline from which to commit fraud. You can find names on lists that are not legitimate, where you know that nobody's going to show up and claim to be that person, then you've got an opportunity to claim to be registered and to serve as an imposter. So that dovetailed with the general idea of trying to clean up and tighten up the security of elections, I think, to give rise to the interest in doing this.
We've got time for one more question here.
In 2008, I was pretty active working for President Obama's campaign, and I got to travel throughout the state of Indiana, and something that we saw pretty pervasively is that the voter ID requirement disproportionately affected students. Students were a population very likely to have this problem because their existing driver license were from out of state, and oftentimes, if they only moved to campus in September or August, they didn't really have sufficient time to establish, to get an updated driver's license. And on top of that, a few of the state schools, not to mention the private schools, while they have state-issued IDs, they didn't have the expiration date on them. And so what students at those schools, for the most part, had to do was encourage the people they were registering to vote to essentially vote absentee, either from their school location or back in their home state of residence. And the question that this is bringing to my mind is, I was wondering if any part of your any part of this case or any part of the debate on this law focuses on the distinction. Like, does it count as voter disenfranchisement to kind of compel these people or place a burden on them to have to vote absentee, a method of voting that typically is not counted quite as faithfully as in-person voting, or to kind of push people out of voting in their preferred jurisdiction?
Well, I mean, I don't think there's any constitutional right to be able to vote in the manner that you prefer. So that did come up and it was discussed, and I think that the way it washes out is that most, not all the judges were sort of treating absentee voting with in-person voting on an equal basis. Now, I think a lot of the critiques center on this idea that somehow there should be the equal ability to go to the polls, but then some people say, well, maybe we all have to be able to mail in. I don't know. I mean, it's just but the point is, you don't have that constitutional right to choose in the manner in which you vote. Now, as for where you vote, sort of your state of registration, the state whose elections you're going to participate in, I mean, I think it's perfectly legitimate for someone who is sufficiently a resident of another state to maintain that state's driver's license to be required to vote in that state. I mean, it sort of goes back to this supposed disenfranchised person from Florida that came out of the woodwork in our case, where, look, this was legitimately preventing the potential for double voting, preventing someone who was not really entitled to vote in Indiana from voting in Indiana. Now, if a student moves to Indiana to go to school, but with the sufficient intention to become a resident, that they can shift their registration, they can go through all of that rigmarole, well, then they assume an obligation also to acquire the proper license, which, if they've already got a license from the home state, is actually not as burdensome as if they had nothing. There was actually, in the case, I remember there was a discussion about this involving some Purdue students that had some trouble or something like that. And it just, you have to boil it down to what is the underlying concern when it comes to students. And one of the underlying concerns is what state are they really living in? Do they claim permanent residency here, or are they just here sort of temporarily, but really owe their residency back home?
But I think you make a good point. I know that the case that Tom is referring to is a case that says that if a person doesn't have a constitutional right to vote by absentee ballot, but whether it's constitutional or not, it's really unfair to require an elderly person, for example, who may have voted at the polls forever, 50 years, and it's part of their civic ritual and regarded as it has a social aspect to it, and so on and so forth, to require that elderly person, because they don't have a birth certificate, to vote by absentee ballot. I don't know whether it's unconstitutional, but if it's not, it maybe should be. Maybe somebody should test that.
Well, it seems, I don't think the question is whether or not, the state can require you to vote in a certain way. I think that pretty obviously isn't constitutional. But I guess the question, the distinction, I think, is that in Indiana, people who have these IDs, they have the right to go vote in person, but the people who don't have IDs don't really have that same right. So the distinction is not so much one of getting to choose how you vote, but the fact that you're being denied a right that other people have.
You're talking about impact, right? Right. Is there a disproportionate impact on a certain segment of the population? And Scalia made a really interesting point about this in his concurrence in the Crawford case, where he said, look, when you look at voting regulations, and you're looking at constitutional questions, you have to look at burdens. What is the burden of compliance? Not at what is the impact of the law. There's a distinction between burdens and impact from his point of view. And I think it's a legitimate distinction. And we worry about impact when we think of traditionally discriminated categories, race in particular, gender to a lesser extent, but still significant extent. But I think student status probably is less disconcerting. I mean, we had all kinds of categories thrown at us in the case about who was going to suffer as a result of this, and one of them was non-drivers. And I thought it odd that we were suddenly seeing a worry about discrimination against non-drivers, not a category you typically associate as a political group, but also in light of motor voter, which had been all the rage in the early 90s, which was based on the idea that most people will go to the BMV to get the driver's license and may as well get a registered to vote there. You can try to carve this up and find different categories of people that you think are going to be impacted in a disproportionate way, but in the end, that's not really a constitutional argument.
I'm sure we'd have more questions, but we're out of
time, so if everyone could give a round of applause.